Good morning, everyone. This is Desiree Johnson. For today's discussion, I am going to talk on the Philippine Competition Act, or RA 10667, and the Anti-Money Laundering Act, or Republic Act number 9160. So let us first discuss on the overview of the Philippine Competition Act, or Republic Act 10667. So, question: why does competition matters? Well, a competition keeps the economy working well. A competitive market is one where there are multiple buyers and sellers. No single entity controls the price of the goods or services. As such, businesses are more attuned to consumer demand and have to innovate to make their products different and better than the rest. Fair market competition benefits the broader economy. Without competition, there is no motivation for companies to provide convenient and fast services to consumers, and no reason to innovate products. While investment flow to markets that are marked by greater innovation, where there is a level playing field and where competition is protected. With greater investments come more jobs, which in turn increase consumption. Ultimately, competition contributes to economic growth and poverty reduction. So the Philippine Competition Act, or RA 10667, was enacted in 2015. It serves as the country's primary competition law. It defines, prohibits, and penalizes anti-competitive practices with the aim of enhancing economic efficiency and promoting free and fair competition in trade, industry, and all commercial economic activities. In RA 10667, there will be a fair chance of level playing field for companies in the country, small or big, to be able to compete in the market. What businesses practices does the PCA prohibit? The PCA prohibit entering into an anti-competitive agreements, for example, price fixing, bid rigging, abusing a dominant market position, and entering into an anti-competitive mergers and acquisitions. So what businesses and entities does the PCA cover? The PCA covers any person or entity engaged in trade, industry, and commerce in the Philippines. It also applies to international trade that may impact trade, industry, and commerce in the Philippines. The PCA does not apply to collective bargaining agreements or arrangement between workers and employers and other such activities affecting conditions of employment. The Philippine Competition Commission. The PCC is the government agency mandated to implement the PCA and the National Competition Policy. It was established in February 2016. The PCC is the main authority on competition-related matters in the country. So what are the powers and functions of the PCC? As the antitrust authority of the country, the PCC is mandated to exercise the following powers and functions. First is to conduct inquiry, investigate, and hear and decide on cases involving violations of the PCA. It's implement the rules and other competition laws. Second, to monitor and analyze the practice of competition in markets and issue advisory opinion, rules, and guidelines on the competition matters for the effective enforcement of the PCA. And lastly, to conduct, publish, and disseminate studies, reports, and other publications on competition matters to inform and guide the industry and consumers. While it has original and primary jurisdiction in the enforcement and regulations of all competition-related issues, the PCC works with relevant sector regulators on matters where the regulators' innate expertise and knowledge in the sector are critical. So how does the PCC conduct investigations? In September 2017, the PCC issued its Rules of Procedure, which governs its investigations, hearings, and proceedings. In initiating and conducting investigations, the PCC shall be guided by the enforcement priorities set by the Commission. Investigations on possible violations of the PCA can be triggered by a verified complaint, motu proprio or PCC's own initiative to look into a case, or referral by a concerned regulatory agency. On the basis of these triggers, the PCC through its enforcement office shall conduct a finding preliminary inquiry PI to determine whether reasonable grounds exist to conduct a full administrative investigations or FAI for any violations of the PCA, its implementing rules and regulations or IRR or other competition laws. The PI shall, in all cases, be completed by the Enforcement Office within 90 days. Upon finding reasonable grounds, an FAI follows the PI to determine whether there is sufficient basis to charge an entity for violations of the PCA, its IIR, or other competition laws. After an FAI, the Enforcement Office shall either file the case with the Commission assuming there is a sufficient basis for violation, or otherwise close the investigation. If there is a sufficient basis, the Commission then proceeds with adjudication to determine whether substantial evidence of the violation of the PCA, its IRR, or other competition laws exist, and to justify the impositions of appropriate penalties and remedies. Final orders or decisions of the Commission may be appealed before the Court of Appeals in accordance with the rules of the Court. So, what are anti competitive agreements? Anti competitive agreements are those that substantially prevent, restrict, or lessen competition. The agreement may be any type or form of contract, arrangement, or understanding between or among businesses to fix prices or manipulate bids. It does not matter if the said agreement is formal or informal, or tacit or in written or oral form. It is illegal for businesses rivals to act together in ways that can limit competition or hinder other businesses from entering the market. So, what are the examples of anti competitive agreements? We have here the price fixing, the output limitation, market sharing, and bid bridging. So, what's in the price fixing? Businesses agree to directly or indirectly fix purchase or selling price instead of letting supply and demand determine the prices of goods and services. While in output limitation, businesses agree to limit production by restricting output or setting quotas, creating an artificial shortage in the market that subsequently drives up prices. Furthermore, in market sharing, businesses divide the market and claim dominance according to territory, customer demographic, sales, volume, or type, creating local monopolies that deprive consumers of choice. And lastly, in bid bridging, businesses agree to fix prices at an auction or manipulate bids, forcing buyers to select the higher priced, pre-selected bid instead of the best price. What are cartels? A cartel is an organization formed by competitors in a specific industry, which enables them to set prices or control levels of production. Agreement to form cartels or collude are considered anti-competitive agreements. Understanding abuse of dominant position. A business may become dominant in a certain industry by gaining a significant share in the market or becoming an industry level by virtue of years in the operation. So, what is abuse of dominant position? In the conduct of their business, dominant companies, considering their size, scope, and position of economic strength, may have a disproportionately severe effect on the market. The PCA defines abuse of dominant position as the conduct of an entity, whether a company or an individual, with dominant positions that substantially prevents, restricts, or lessens competition in the market. Also, take note, it is not illegal to be a dominant provided businesses do not abuse their dominance. So, how do firms abuse their dominant positions? Markets that are dominated by a single or a handful of large companies are particularly vulnerable to anti-competitive practices. Such conduct that might indicate abuse of dominance includes the following. In predatory pricing, a dominant firm deliberately incurs losses in the short term by selling goods or services below the cost of its production, which can eventually force its competitors out of the businesses. In price discrimination, a dominant firm sets different prices or conditions for equivalent transactions. In exploitative behavior towards consumers, customers, or competitors, a dominant firm charges excessive or unfair prices or employs other unfair trading conditions. And lastly, in limiting production markets or technical development, a dominant firm restricts output or refuses to supply or restricts access to or use of development of new technology to the detriment of the consumers. It is not illegal to be dominant provided that a business does not take advantage of its dominance to substantially lessen competition in the market. Understanding mergers and acquisitions. So, what are mergers and acquisitions? Mergers refers to the joining or two or more entities into an existing entity or to form a new entity, while acquisition refers to the purchase of securities or assets of the purpose of obtaining control of other entity. M&As can benefit consumers because they may lead to businesses that operate more efficiently, enable the transfer of technologies, broaden access to capital, and increase productivity. However, there are M&As that harm competition and can be disadvantageous to consumers. So which M&As violate the PCA? Not all M&As are prohibited. The PCA prevents M&As only if they substantially lessen competition in the Philippines. For instance, M&As that create companies with dominant market power could potentially lessen, restrict, or prevent market competition. The PCA conducts merger review to predict a proposed M&A's competitive impact. The review process involves rigorous economic analysis and investigations to determine whether transactions might harm consumers. There are three triggers of merger review. These are the notification by merger parties, motu proprio or PCC's own initiative, and the third-party complaints. The PCA provides a compulsory notification by parties to the M&A's agreement, subject to notification threshold for both sides of transactions and the size of the person to be determined by the PCC. The size of the transaction refers to the value of the assets or revenues of the acquired entity. Size of the person refers to the value of assets and revenues of the ultimate parent entity, including entities it controls of all at least one of the parties. So, what will the PCC do to an entity or entities found violating the PCA? The PCC is empowered to impose fines and penalties on businesses whose conduct or activities violate the PCA. Those found to be in contempt, fail to comply with orders or supply misleading or false information to the PCC. Administrative fines for violations of 14 anti-competitive agreements, 15 abuse of dominant position, 17 compulsory notification, and 20 prohibited mergers and acquisitions. In fixing the amount of fines, the commission shall consider both the gravity of duration of the violation in cases involving basic necessities and prime commodities as defined in the Price Act of 1992 or Republic Act number 7581. The fine shall be tripled. Fines ranging from 50,000 pesos to 2 million pesos for failure to comply with an order of the Commission. Businesses that fail or refuse to comply within a ruling or order of decisions issued by the Commission are required to pay the above penalty for each violation and a similar amount of penalty for the day each afterwards until the businesses fully complies. Fines up to 1 million pesos for the supply of incorrect or misleading information. This fine is applicable to any entity that wittingly or unwittingly supplies incorrect or misleading information in any document, application, or other paper filed with or submitted to the Commission, or supplies incorrect or misleading information in application for a binding ruling, a proposal for a consent judgment, proceedings relating to a show cause order, or application for modification of the Commission's ruling, order of approval as the case may be. Fines worth at least 50,000 pesos for any other violation not specifically penalized under the relevant provisions of the PCA. This schedule of fines shall be increased by the Commission every 5 years to maintain the real value from the time they were set. Only the Court of Appeals and the Supreme Court may issue a temporary restraining order or injunction against the PCC in the exercise of its duties and functions. So that will be the end for the topic, the Philippine Competition Act or Republic Act number 10667. Now let's move on to the Anti-Money Laundering Act or Republic Act number 9160. So the Republic Act number 9160, otherwise known as the Anti-Money Laundering Act of 2001, was signed into law on September 29, 2001 and took effect on October 17, 2001. The implementing rules and regulations took effect on April 2, 2002. On March 7, 2003, RA number 9194, an act amending RA 9160, was signed into law and took effect on March 23, 2003. The revised implementing rules and regulations took effect on September 7, 2003. So, what is a money laundering? It is a scheme where the proceeds of unlawful activities specified in the law are transacted or attempted to be transacted to make them appear to have originated from legitimate sources. AMLA is the process of making dirty money looks clean, and it occurs when the funds from illegal activity are integrated in a financial system to make it appear that it belongs to a legitimate source, by hiding all the money or the sources of moving the money to a place where it is less likely to attract detention. Now let's talk about the purpose of AMLA or the Anti-Money Laundering Act. It is to protect and preserve the integrity, confidentiality of bank accounts, and to ensure that the Philippines shall not be used as a money laundering site for the proceeds of any unlawful activity. RA 9160's enactment was government's response to the concerns of Financial Action Task Force to establish international standards and to develop and promote policies up to the international levels to combat money laundering and financing of terrorism. Now, what is a lawful activity? It refers to any act or omission, crime, or series of combination thereof involving or having direct relation to the following. So these are the following act that is related to unlawful activity. These are the kidnapping, the drug trafficking, graft, plunder, robbery, wetting, piracy, qualified theft, swindling, muggling, violations under Electronic Commerce Act of 2000, hijacking, terrorism, financing of terrorism, bribery, frauds, malversations of public funds and property, forgeries and counterfeiting, human trafficking, violations of revised forestry code, violations of the Philippine Fisheries Code of 1998, violations of the Philippine Mining Act of 1995, violations of the Philippine Mining Act of 1995, violations of the Wildlife Resources Conservation and Protection Act, violation of the National Caves and Cave Resources Management Protection Act, violation the Anti-Carnapping Act of 2002, violations of the decree codifying the laws of illegal and lawful possession, manufacture, dealing in, acquisitions, or disposition of firearms, ammunition, or explosive, violations of the anti-fencing law, violations of the Migrant Workers and Overseas Filipino Act, violations of the Intellectual Property Code of the Philippines, violations of the Anti-Photo and Video Voyeurism Act of 2009, violations of the Anti-Child Pornography Act of 2009, violations of the Special Protection and Children Against Abuse, exploitation and discrimination, fraudulent practices, and felonies and offenses to similar nature. The Anti-Money Laundering Council, or AMLC, is the Philippines' financial intelligence unit tasked to implement the AMLA. It is authorized to inquire into or examine any particular bank deposits or investments that are deemed related to unlawful activity or money laundering offenses. The council is composed of the governor of the Bangko Sentral ng Pilipinas as chairman and the commissioner of the Insurance Commission and the chairperson of the Securities Exchange Commission as members. It acts unanimously in the discharge of its functions. Anti-money laundering involves three stages as follows. These are the placement, the layering, and the integration. In placement, the physical disposal of the dirty money. The money is placed in a financial system through banks, casinos, and shops and other businesses. This phase can involve different kind of transactions, like breaking a large amount of money into a smaller sum and depositing them directly into bank accounts, transporting cash across borders to deposit money in financial institution abroad, or to buy precious goods such as diamonds and golds that can be then resold for payment through check or bank transfer. In layering, the separation of the dirty money from the source by creating layers of financial transaction to disguise audit trail. The money is moved to different accounts through series of financial transactions designed to hide money origin. These layering fees can involve legitimate transactions like investing in real estate and lawful business, placing money in investments such as stocks and bonds. And lastly, in integration, where the dirty money is given legal identity, making it clean. The funds are reintroduced in the economy so that they appear to belong in a legitimate source. This does not only help the criminal to clean the dirty money, also for investments makes profit out of it. As a result, integration stage it is exceeding difficult to distinguish between legal and illegal money. In Section 4, Money Laundering Offense, the money laundering is a crime whereby the proceeds of unlawful activity are transacted, thereby making them appear to have originated from legitimate sources. It is committed by the following: any person knowing that any monetary instrument or property represents, involves, or relates to the proceeds of any unlawful activity, transact, or attempts to transact said monetary instrument or property. Any person knowing that any monetary instruments or property involves the proceeds of any unlawful activity performs or fails to perform any act as a result of which he facilitates the offense of money laundering referred to in paragraph A above. And C. Any person knowing that any monetary instrument or property is required under this act to be disclosed and filed with the Anti-Money Laundering Council fails to do so. Bank Depository Inquiry. In Section 11 of Republic Act No. 9160 provides authority to the AMLC to inquire into or examine any particular deposits or investments including related accounts with any banking institution or non-bank financial institution upon order of any competent court based on an ex parte application which has been established that there is probable cause that the deposits or investments including related accounts involves are related to an unlawful activity. The authority to inquire into and examine the main account and the related account shall comply with the requirements of Article 3, Section 2 and 3 of the 1987 Constitution. So, guys, if you're going to deposit a large amount of money in the bank, please don't be offended if the teller or customer associate asks you the source of the deposit or the reason for your deposit, because we're just making sure that your money does not come from an unlawful activity and it is legal. So these are just some preventives in committing the unlawful activity. First is a customer identification requirement, where covered institutions shall establish and record the true identity of its clients based on official documents. Next is the record keeping. All records of all transactions, including closed accounts of the covered institution, shall be maintained and safely stored for 5 years from the days of the transaction or when they were closed. And lastly, in report of covered transactions, covered institutions shall report to the AMLC all covered transactions within 5 working days for the occurrence thereof, unless the supervising authority concerned prescribes a longer period not exceeding 10 days. Penal provisions. A. Penalties from the crime of money laundering. The penalty of imprisonment ranging from 7 to 14 years and a fine of not less than 3 million Philippine pesos, but not more than twice the value of the monetary instrument or property involved in the offense shall be imposed upon a person convicted under Section 4A of this Act. the penalty of imprisonment from 4 to 7 years, and a fine of not less than 1,500,000 Philippine pesos, but not more than 3 million Philippine pesos, shall be imposed upon a person convicted under Section 4B of this Act. The penalty of imprisonment from 6 months to 4 years, or a fine of not less than 100,000 Philippine pesos, but not more than 500,000 Philippine pesos, or both, shall be imposed on a person convicted under Section 4C of this Act. And B. Penalties for failure to keep records. The penalty of imprisonment from 6 months to 1 year, or a fine of not less than 100,000 Philippine pesos, but not more than 500,000 Philippine pesos, or both, shall be imposed on a persons convicted under Section 9B of this Act. C. Malicious reporting. Any person who, with malice or in bad faith, report or files a completely unwarranted or false information relative to money laundering transactions against any person shall be subject to a penalty of 6 months to 4 years imprisonment and a fine of not less than 100,000 Philippine pesos, but not more than 500,000 Philippine pesos, at the discretion of the court, provided that the offender is not entitled to avail the benefits of the probation law. D. Breach of confidentiality. The punishment of imprisonment ranging from 3 to 8 years and a fine of not less than 500,000 Philippine pesos, but not more than 1 million Philippine peso, shall be imposed on a person convicted for violation under Section 9C. So that will be the end of my report on Anti-Money Laundering Act, or RA 9160, and the Philippine Competition Act, or RA 10667. I hope you have learned something from me, as I have learned a lot of what I have discussed. Thank you and God bless.